Well, good morning, everyone. My name is Tim Kellett. I'm from Paydata, and welcome to today's webinar about taking tough decisions in obviously tough times. I am delighted that joining me is Jonathan Chamberlain from Gowling's international law firm. Just ahead of today, a few housekeeping things. We've muted everyone's microphones. If you've got questions that arise as we go through today's webinar, please put them in the Q&A section, and we will endeavour to get to them at the end of the session. If we run out of time, we're due to spend an hour today, so if we run out of time, we will get to the questions and contact you separately. So that's that. So as I said, I'd like to introduce Jonathan Chamberlain, who's a partner at Gowling's, and Jonathan's going to be taking us through today's discussion. So welcome, Jonathan, and I will place the webinar in your capable hands. So off you go.
Thanks, Tim, and good morning. Welcome to another webinar. I don't know about you, but I've been to a lot of webinars since all this wretched business started, and I am now quite used to seeing a screen with a slide on it and a little window about an inch big in the corner with a tiny little face on it of someone talking. And I'm a bit bored with that. And I really don't want to do any more webinars. That's not a great way to start off a webinar I'm doing with you, is it? But I really don't want to do any more webinars. I would much rather that we went and had a coffee. So I've got my coffee. I hope you've got yours too. And that we chat about this difficult topic. So please do use the Q&A function. Tim will try and feed in questions as we go along. I won't be looking at them because I'd rather be looking at you, obviously. But hopefully we'll be able to pick things up at the end. Now, we've called this webinar Taking Difficult Decisions in Tough Times. A better way of putting it might be implementing difficult decisions in tough times. And what we're going to be talking about this morning is the really hard stuff that we have to do in our job about looking at an individual in the eye and letting them go, terminating their employment. There's never a good time to be doing that. Right now, in the middle of a pandemic, and I suspect we are still in the middle. I think the next year or so is going to pan out very differently, I hope, to the last couple, but everyone I speak to says this is going to carry on for a while longer. It is even harder than it would be during more normal times. So what I'm going to talk about this morning is three things. First, I'm going to talk specifically about what I think has changed during a pandemic. Then I'm going to just go back to first principles on the money, calculating how much we think is a good offer, something that will get the deal done, something that will make this easy so we can do a deal rather than landing ourselves up in litigation. I'm not going to talk about the principles of how we fire somebody fairly or how we don't discriminate against people. I'm assuming, frankly, that you will know all of that. And in any event, it's very rare that those issues knock on the front door for us in a way that something like this does. This is where we've taken a conscious decision that someone has to go. We may or may not have a good reason for it. It may just be we think it's the right thing for the business, and that's why we're having the conversation. So I'll talk about the things that gets the deal done, the money. And then finally, I'm going to touch on the mechanism that the law does provide to facilitate those sorts of discussions, the protected conversations, as it's called, because I think it's useful to remind ourselves of what those can do and what they can't. So that's what we're talking about, the practicalities of firing somebody, how it actually works in the real world. We're not going to deal with all the practicalities because I'm a lawyer. I tend to sit in the room next door, as it were. I have actually had to look people in the eye and tell them that their employment is over. I have actually had to suspend them. I have gone through all that stuff. So I do have some experience, but my experience in those cases probably won't be as great as yours. What I do see, and where I am confident that I can help, because this is the reason why you talk to me, is on once you're in one of those situations, how do we make it all right? Because obviously I see thousands of those literally in the course of my career. And hopefully, even if you are a battle-hardened veteran of this, you won't be seeing more than a few dozen. So let's go straight to the main point, the implementing the tough decision in the tough times. What has changed in this process as a result of the pandemic? And I want to talk about two things. One is mitigation, one is litigation. And I'm going to start off with mitigation, because when I was discussing this topic with a friend who's also a lawyer, who works in a firm where they mainly act for individuals. Gowling, as Tim said, we're an international law firm, and our clients are employers for the most part. We do occasionally act for ex-employees. Every good gamekeeper needs to go poaching once in a while. So we do it from time to time, but not very often. So I was speaking to a friend of mine who works in a firm on the other side, definitely the professional poacher. What difference has it made? And he said, none. I thought, okay, this is going to be a short talk then. And he said, except for mitigation. That's a bit like the old joke, well, apart from that, Mrs. Lincoln, how did you enjoy the play? You know, this is the central event, the central talking point, the legal talking point, what frames, as we're going to see in a moment, the discussion around compensation. It's mitigation more than anything else that drives how much money you're going to have to pay somebody to make this go away smoothly. So just reminding ourselves of what the principle of mitigation is. If we terminate somebody's employment and we don't make them work their notice, we make a payment in lieu, then as we'll see in a moment, the amount of that payment in lieu is driven partly by the length of the notice period and partly by the principle of mitigation, but also compensation for unfair dismissal, compensation for sex discrimination, any form of compensation really, apart from certain very defined attributes, attributes is the wrong word, defined sums of money, the basic award for unfair dismissal, the statutory redundancy payment, payments for injuries to feelings, they all ultimately relate to loss. In this country, we are spared the American system of punitive damages, exemplary damages. We do get in the employment tribunal aggravated damages in certain circumstances, but they're so rare. It's really all about how much has the individual lost as a result of being unfairly or wrongfully terminated. And that's what mitigation is about, because how much they've lost is how easy is it for them to find another job. And of course, the person who's being fired will say, I'm never going to find another job. It's going to take me a year to find another job, 2-3 years to find another job. In practice, the employment market tends to be a bit more buoyant than that most of the time. And depending on the nature of the job, it might take somebody, a more junior employee, days to find another job. It might take someone weeks or months, very occasionally years, but not often. And the point about mitigation in the pandemic is that those periods of days, weeks, months, whatever they are longer. So someone who is being fired is going to be more frightened they're not going to get another job quickly, and is going to want more money to make themselves feel safe. And even if it's not the reality, because, for example, in some sectors, life sciences would be a good example, then actually it's much easier for them to find another job. Healthcare, it's much easier for them to find another job at the moment. The pandemic has had the reverse effect. And other sectors, professional services, for example, are largely unaffected. Of course, hospitality and leisure, bricks and mortar retail, outside food, pandemic effects are brutal. So that is the primary effect of letting someone go, in tough times, is they are going to be looking for more money, and the law will support them in getting more money. We're going to come on to a moment into how much money they might get, because that's really important to factor in sort of what realistic expectations people should have in these circumstances. But there's no doubt that as times are tougher, people are more frightened, they think that they need more money, and in some cases, the law will back them up on that. So that's an important thing to bear in mind when you go into one of these situations. Now, the second point that I wanted to make about how these times are affecting these sorts of negotiations is about litigation. Okay, now, having promised you that this was going to be a very practical discussion and that we weren't going to be looking at legal principles, you may be thinking, why on earth are we going to be talking about litigation? Now, the whole point of this exercise is that we don't want litigation. We want to reach agreement. We want to manage this away. And that's absolutely right. But what takes place in litigation conditions the negotiation process. And it does that, I think, in two ways. The first is the starting point when the organization is letting an individual go, is that once the individual's out the door, this is much easier for the organization than it is for the individual. It's like it's like a breakup, isn't it? Life is always much easier for the dumper than the dumpee, you know, because once they're gone, we can move on with our life. The dumpee is dealing with the consequences. And it always used to be thought of as a trope amongst employment lawyers and HR professionals that the prospect of litigation was so awful that it would mean that an employee, an ex-employee, would want to settle. They were on their own. They don't have the weight of the organization across which they can spread the burden of all of this. And all of that remains true. No one in their right mind wants to litigate. And I'm a lawyer, okay? I think litigation is the best toy and scale extric. And if you will pay me to play with it, I could not be happier. But no sane person wants to get involved in litigation, particularly not an individual. However, and this is the pandemic effect, that dynamic changes over time. If an individual is really committed to litigation, then they're probably a little bit mad to start off with, and that then starts to work against the ex-employer as the process wears on, because the longer the process takes, the less invested the organization becomes in it. People forget, memories fade, people have moved on to different things. They don't want to keep being dragged back to this case which happened weeks ago, months ago, years ago. And here's the thing about years ago. This is the crucial point about the pandemic. Things are taking much longer. Okay. Now, I'm a lawyer, and as one of my partners puts it, there are three kinds of lawyers: those who can count and those who can't. But even I can look at the numbers and see what's happening. Okay. Like for like cases, individual claims are up year on year by 13%. Okay. But the effect of the pandemic, last time the statistics were cut, which was a few months ago, was that tribunals were hearing 40% fewer final hearings. So number of cases into the system going up, number of cases coming out of the system, because that's final hearings, going down, the system is clogging up. Now, the tribunal staff are working frantically to try and clear the backlog. And in many cases, they are succeeding. Things are not nearly as bad as they were at the start of the pandemic. But we have to remember they were starting from an appalling position of lack of investment in court infrastructure. So it was not possible for tribunal staff to work remotely. They had to come into the office, and some of the offices were closed. You could make them COVID safe. Central London Tribunal, the busiest in the country, was completely shut because the air conditioning, it turns out, was a COVID spreading machine. So the whole building had to be closed down. And so there were cases in there and things were coming in paper, emails were being unanswered. And even now, cases which were filed in January by claimants are still not coming out to employers. That problem is getting bad, but we're still getting cases that were filed months ago coming through. So there's that sort of delay. Now, for an individual, of course, that delay is terrible because it means they don't get access to money, et cetera, et cetera. But for an organization, it is also problematic because you won't have taken witness statements when the incidents that are complained of first happened. You won't think you'd have needed to. You certainly won't want to. It's a huge investment. You won't have gone through a discovery process at the time. You'll be hoping that you could settle all of this. Why would you do all of that? And so the organization becomes vulnerable. As memories fade, as people get less interested, and you can find yourself in a hearing 2 years down the line. I've heard of 3 years. I mean, I've heard of one, which is actually 6 years. That is an outlier. But a year is sort of normal, really. 2 years, not uncommon. And people have moved on, and people don't care, and people have forgotten. And you can find yourself having to face a hearing. The witnesses don't even work for you. They're in different jobs. They don't have any more memories. You're in a terrible position. And that is an effect that the pandemic has had. Yes, in the short term, that can sort of work for you, but ultimately it's not good. And so the business maybe say, well, they're never going to get a case on in months or whatever, and it'll take them ages. That's great for us. Well, yeah, it might be, but later on it could be awful for us. So that is something very much to bear in mind. Now, that, if you like, is the new stuff. Okay, that was the first thing I was going to tell you about. How has the pandemic made a difference? And I hope you appreciate the way that I haven't structured this like EastEnders. Okay, you did not have to wait for the duffs to get the interesting bit in the program. We've had that up front. And if you are an old hand in terminating people, a lot of what follows for the next sort of 30 minutes or so is largely going to be recap. So if you want to switch me onto your second screen and get on with checking your emails at this point, that's absolutely fine. I will not be offended.
Perish the thought, Jonathan.
If you're still here for the coffee, and I hope you are, then let's just start framing that conversation about money a bit more. And what I want to talk about here are firstly, the basic principles of compensation. And then I want to talk about what figures are actually awarded in practice by tribunals. And then I want to talk about what that means for you in structuring your opening offer. So, excuse me while I just take a sip of coffee. I hope you'll do the same. Oh, right, my caffeine hit for the next bit. So, what are the basic principles? They are fiendishly complicated. This should be easy, but it's actually really tricky, because we have in the UK, almost uniquely, in my experience, in Western countries, this dual system of employment protection rights. You have the private bargain, the contract of employment, And then you have the statutory employment protection regime, which sits alongside that. And how the two interact in terms of compensation and money is really subtle and quite difficult to get your head around. And if we had longer, I could tell you how all this mess came about, because it's all to do with history and unions and politics. And none of it is really to do with anybody sitting down and thinking, how should we actually protect employees' rights in the workplace? It's just sort of happened. But now I suspect isn't the time for that. We can have another coffee at some point. We'll go through that. Right now, let's just deal with what that actually means in practice and acknowledge to ourselves that this is difficult. And it can be very difficult to explain to whoever is the budget holder for all of this. Let's start off with a contract. I touched on this a moment ago. Any contract, everybody has a contract of employment in this country, whether it's written down or not. You will work for a business which, because you're in it, is going to do the right thing, and there are going to be written contracts, and they are going to comply with the statutory minimum notice periods at the very least. So you'll be able to see what notice period someone has got. If someone hasn't got a contract, then a court will imply reasonable notice, and they'll look at seniority, and they'll look at industry practice, and they'll look at what other people have had and that sort of thing, and they'll come up with a sort of figure. But for most employees, notice periods are between 1 and 3 months. More senior, 6 months, occasionally 1 year. The days of the 3-year rolling notice period are now, I think, behind us. When I was a young lawyer starting off, they were very common at senior levels in companies. They've now gone. It's very rare for any of us to come across a notice period of more than 1 year. And the vast majority that we will deal with are up to 3 months. Now, if we give someone notice, that's easy. They work out their notice. There's no money due. They just carry on working. If we put them on garden leave, same thing happens. They leave the business, carry on working. If we have a payment in lieu clause in the contract, which allows us not to give them notice, but to pay them money instead, then again, it's very simple. And contracts will hopefully be clear about what goes into that payment in lieu. Is it basic salary? Is it salary plus bonus? Is it salary plus benefits? But no doubt in the organization that you work for, because you're in charge of the contracts, it's all clear what that will be based on. Where we have to think about the legal principles are if someone's on 3 months' notice, but we want to terminate them immediately. How much compensation might they be entitled to, calculated by reference to the contract? Let's just leave the statutory position on one side for the minute. As I say, the interaction is complicated. So right now I'm making it really simple just by ignoring it. We'll come back to it later. The starting point is that 3 months notice equals 3 months money, but the individual is only entitled to be compensated for loss. So if they leave on the Friday and they get another job identical on the Monday in terms of remuneration, they haven't lost anything. So you don't owe them anything, even though you may have breached the contract. So this is where this principle of mitigation comes in. How likely is it that they're going to get another job? Now, I tend to take the view that with a 3 month notice period or shorter, having an argument about mitigation is not terribly productive, because it's quite easy for someone to say, I'm not going to get another job in 3 months. And unless the industry is particularly buoyant, or they're a particularly junior employee where, you know, if you've been working in one fast food chain on a Monday, you could actually quite easily walk into another fast food chain on a Tuesday, and you could flip chicken instead of burgers. Fine, you know. But for most jobs where we'd actually care about this, I don't think a 3 month notice period is worth arguing about. I think a 6 month period might be, and a 1 year period definitely. But 3 months, probably not. However, why are we having this conversation? because I'm now going to bring in the statutory compensation piece, which sits alongside the contract. Because as I trailed earlier, if we're compensating somebody for infringing their statutory employment protection rights, then certain sums of money are earmarked for certain things. There's the basic award for unfair dismissal, which you recall is between 1.5 weeks pay per year of service, depending on age, weeks pay capped at £500, capped at 20 years altogether. And so that works out, generally speaking, a few hundred or a few £1,000s per employee, but there's a formula, you can do the maths. There's then also injury to feelings and discrimination cases between £5,000 and £30,000, depending on the seriousness of the injury. And there are bands, middle, low, high. Every employee says, this is really high, this is dreadful what you've done to me. And it almost never is. And that's mainly because you will be horrified at the things that people have done over the years to their employees. So these are actually, I'm not making any of these up. One workplace where the employees thought it would be amusing to brand one of their colleagues with a hot iron. Funny enough, that's the top end of the band. Another one in the fire service. This is going back a long way. Fire service has changed a lot since then, where they thought it would be really amusing to take a female recruit and hose her down with the fire hoses in the yard. So that's the kind of thing we're talking about at the really top end. Most things fall within the middle band, actually, like you'd expect. But those have their own, that has its own distinct system of calculation. For most compensation, the formula the court used is what is just and equitable. And what that really means in practice is, again, how quickly can the employee find another job? We're back to that mitigation idea. But they might already have 3 months' notice off you by way of a payment in lieu of notice, or because that's the amount that you're attributing to the contract. Okay, how does that work out? Is it an automatic set-off so that the tribunal will calculate that you're going to be out of work for, will come up with a number and then they'll deduct the pile-on made? No, this is where the subtlety comes in. The tribunal start from, okay, what have you lost between the date that you lost your job and the hearing? And we can fix that and work out what happened. And then we look what's happened in the future. So I realize I'm pressing these out of camera. So the useful sort of spectrum illustration I'm giving you is not actually showing on the screen. My apologies. What that can mean, therefore, in terms of negotiating the compensation with somebody, which is what we care about for the purposes of this talk, then we're going to look at how long we think they're going to be out of work overall. And I'll come on to what I think that means when we look at the third point I was going to make under this heading, which was around what do I think is, good practice in terms of opening offers and stuff like that. Right now, I'm going to come on to the second point, which is what awards the tribunals actually make. Because I think this is really important in terms of framing people's expectations. You know how doctors hate you consulting Dr. Google, because Dr. Google will always tell you you're going to die. You have a slight numbing sensation in your foot. You need to have that amputated next week. That's sort of how Dr. Google works. And it's a bit like that with employment rights. I have been discriminated at work. You are. So that's what people have in their heads. And it's hugely frustrating sometimes. Because actually, tribunals very rarely give out the big numbers, and helpfully the government publish what numbers they do give out. So we've got the sort of 1920 figures now, and they're really interesting. The average award for unfair dismissal, for example, was £10,812. call it 11 grand. Okay, now that's really interesting because you will all know that the maximum compensation for unfair dismissal is up to 1 year's salary, or roughly £80,000, whichever is the lower. So the amount actually awarded is about, I mean, as I say, three kinds of lawyers, those encounters, but somewhere it's just over a tenth, isn't it, of the amount. I think I'm Tim's nodding, he can count, so that'll do. Okay. It's really nowhere near the maximum figures. And an extraordinary thing is that the median award, okay, so the award that most people get, is even less. It's just over 6.5 grand. So that's well under 10% of the maximum. Now, even if you think about that in terms of the average salaries, I'm not sure where we are now, because of course the COVID numbers have totally distorted everything. But average earnings in this country used to be around, a year or so ago, 2 years ago, about around 25k. Okay, and so if the median award is 6.5 thousand, you're talking about what, 25%? Of the national. So you can immediately then start to see how that might work out. And again, a statistician amongst you would be horrified at what I'm about to do. They would say, no, that doesn't work at all. But in terms of coming up with a rule of thumb, you can see, well, if someone gets an unfair dismissal award of the median award is 6.5 thousand, and the median national salary is around 25,000. then we can scale that up. So if we're firing someone on 50k, they'll probably get around 12k for an unfair dismissal award, because that just, I mean, there's no science to that, okay? There's all sorts of reasons why that's wrong, but in terms of setting expectations, okay, it's quite useful, I think, in terms of how we frame this. Might astonish you to learn that in some cases where compensation is uncapped, so for race discrimination, for example, the average award is lower. It's just under 10 grand. The median award's a bit higher, it's just over 8 grand, but you're not seeing enormous sums of money. Sex discrimination, the figures get bigger, median award 14k, average award 17k. Disability discrimination, again, at slightly bigger numbers, 13k for the median, 27k for the average. But that's all distorted because the highest awards in disability discrimination is over £250,000. Similarly, age discrimination, the highest award is over £250,000. But those are cases where you get people towards the end of their careers who are looking at years of loss. For most people, it's not like that at all. And the median awards, again, for that are low, 11k, 13k. So, despite the fact that Google will tell you you've got unlimited compensation, the actual numbers awarded tend to be quite small because people get other jobs.
Jonathan, I had a couple of questions actually come up. One is, how are these compensation levels affected by length of service? So for those with less than 2 years employment, for example?
Right. Well, for those with less than, okay. That's an interesting question. Someone with less than 2 years service is not entitled to claim plain vanilla unfair dismissal. However, discrimination rights are day one. Now, how are these taken into account? As a matter of law, in theory, not all that much, actually, because you're looking to actual loss and future loss, not so much the circumstances as pre-dismissal, as it were. You hadn't been there for long. And if you think about it, in cases of discrimination, for example, that's got to be right. You're looking at the seriousness of the act that's been complained about, not about how long they're there. Someone who arrives on the first day and is subject to a horrendous act of discrimination should be just as much protected as somebody who's been there for years. However, in practice, length of service works itself out in a couple of ways for the less than 2 years. The first is tribunals subconsciously look at people who haven't been there that long and think, well, you haven't been there that long. I mean, they shouldn't, but they sort of do, in my experience. And secondly, as a formal legal matter, of course, if you have been there for more than 2 years, then that's where the basic award calculation comes in. That's that formula, if you remember, of a week's pay per year of service. So that's where it makes the difference. I can see what another question on the screen. Yep. Tim, do you want me to pick up on that one?
Yes.
One now. Do the stats related to unfair dismissal awards take into account constructive unfair dismissal too, or are there different stats for that? I don't know is the short answer. I don't think so. I don't recall seeing those statistics separately. Lots of the cases are constructive unfair dismissal. At least the individual cases that we're talking about in these scenarios, we will be looking at constructive unfair dismissal. Because the scenario I have in mind for this morning's talk is the classic one of where we want someone to go because their behavior isn't great, but is it really misconduct, or do we want to go down that route? Or their performance isn't great, but do we want to go on a performance improvement process? Or we're doing a restructuring and it isn't really a redundancy as such. It's those kind of individual donations which make up the workaday stuff of an HR professional. At the moment, post-COVID, in the pandemic, we're seeing a lot of cases arising out of big formal redundancy exercises where it isn't constructive dismissal, it's no actual dismissal. We intended to fire you. And that's, a lot of the cases driving the stats now are coming from that. So all the airlines that laid off people, all the shops that laid off people. Yes, you had the furlough scheme, but organizations still made huge numbers of redundancies. And they were formal dismissals. And the principles involved in dealing with that are very different, because then you're not so much concerned with individual cases, you're concerned about setting examples, or you're concerned about fighting broader principles, some of which you may think, I've got to fight this because we're going to win. Sometimes you may think, I really don't want to fight this because we're going to lose, and there's another 10,000 people sitting behind this one if it goes public. So those are very different issues. But constructive unfair dismissal, I suspect, forms a lot of what we are considering in these sort of day-to-day scenarios, as it were. And as to mental health issues, does that have an effect on the tribunal claims in terms of the awards and the ability to secure another job? The answer to that is yes, it does, and where that sounds is in the injury to feelings, because that's where they take into account what you might call psychiatric injury. And if you have damaged someone's mental health, I can think of one case where I'm dealing with at the moment where this didn't go to a tribunal because of the way the organization handled it, and they handled it really well. But by heavens, it would have been ugly if we'd gone to tribunal, because you had the classic case of the conference, the away day, the senior man, the junior woman, alcohol. I'll leave you to work out the rest, but it's nasty. It's nasty. Someone is very lucky this didn't go to the police. And what makes it even worse was this was a vulnerable young woman whose mental health was known by her and by the company to be fragile. And the company were working around that, as they should, as a good employer, and supporting her and helping her. And you can imagine the effect that incident then had on her mental health. Now, the company lots of sick pay, lots of helping her come back into the organization, etc. The manager's feet didn't touch the ground. He was out of the company so quickly, and that was all dealt with. But had she brought the harassment complaint, the discrimination complaint, she would have won without any question at all. And the injury to feelings would have been at the top end of the spectrum, because this woman's mental health took a massive hit as a result of this sexual assault. So that's where it would sound itself out in that. Does it sound itself out in the lesser cases of, I am stressed out because of the pandemic and I'm finding coming to work really difficult in any event? Not as much, I think, which is perhaps unfair, but we're all feeling that to some extent, aren't we? At this point, this is hard. It's funny, isn't it? You'd think at what, 16 months into this now, we'd be used to it, and I suppose we are used to it. And actually, it's still difficult, isn't it? It does have an effect on all our mental health, and that is perhaps something. And actually, let me just bring this up at this point. This was going to be my closer, as it were, but I'll deal with it now. That is a real practical point to remember when we are dealing with people at the moment. Everyone is vulnerable. Not just the individual that's going, but you and the managers. Everyone's a bit more on edge. Everyone's a bit more tired. Everyone's a bit more frightened. I say everyone, these are terms. There are some people who are loving this way of working. But I think a safe assumption is that this is hard on all of us, that this takes it out on all of us in different ways, that we've all had new pressures and had to adjust to new ways of working that have cost us in some way or another. And my view is that being a little bit more generous, for want of a better word, around the financial settlements helps everyone in these circumstances. And when someone leaves an organization, it's never actually about the person who's going. Again, forgive me, you're HR professional. The HR professional, I'm teaching you how to suck eggs here. But it's not about the person who goes, it's about the team that stays. How are they in these circumstances? They need to know that their former colleague has been treated as they would see it fairly. And remember, no one has more friends in an organization than someone who's just left. Even if everyone in the office loathes them, even if you think the natural reaction would be relief, oh, thank God they've gone. It never is, not on the first day. Because on the first day, everyone's looking over their shoulders and thinking, God, that could be me. And if you handle this properly and it all goes smoothly, then 2 or 3 days later, a week later, it was, oh, remember so-and-so, isn't life easier now they're not here? But get this wrong, and the impact on the people who stayed is horrendous. And just be considerate of yourself and the manager who's going through this. If you're trying to nickel and dime stuff, then you're adding a harshness to your working life, you're adding a harshness to their working life that they just don't need right now. So that was going to be my big closing point. I hope that you're all sort of awake for that, because I think that one's quite important. And we haven't got much time left. I wanted to talk about protected conversations. So I'm just going to bring in that very briefly before we open up for more Q&A. Generally, the protected conversation process is something that was introduced a few years ago to get round an issue that you could not have without prejudice conversations until you had an actual dispute about which to have without prejudice conversation. Again, you'll recall, you're all professionals, that if you've got a dispute, then in order to facilitate settlement of that dispute, you can speak to somebody without prejudice. And that expression comes from without prejudice to the fact that I think you've got no case whatsoever and that we're definitely going to win this, I'm going to make you an offer to settle. To the reply comes without prejudice to the fact that I think you are appalling and disgraceful and the worst employer ever, I might be prepared to take your money if you double it. And that's hence the expression without prejudice. But you can't do that until you've actually got a dispute. And that would stop you from going to an employee and tapping them on the shoulder and saying, look, things aren't working out. So we can either go through a disciplinary process, at the end of which you'll probably be fired, or a performance improvement process at the end of which you'll probably be fired, or you could have some money to go away. And you couldn't do that without prejudice, which means that the court or tribunal would get to hear about it. And of course, they would conclude from the fact you'd started this approach that really, before you'd even gone into the process, your mind was made up. So it wasn't really a proper process, was it? The employee never had a chance, so you're going to lose. And that meant that we were having to put people through disciplinary processes, through performance improvement processes that they didn't want to go through, even if maybe they could come out of it the other side. They just didn't want to stay and hang around anymore. They didn't want to go through that process. So it didn't suit anybody. So this idea of the protected conversation was introduced. But the point that I want to make about that is, I haven't got much time left, is one, if you're going to do it, follow the ACAS code every time, look it up, refresh your memory, tap in ACAS protected conversations, woof, it all comes out at you. None of the legal textbooks say anything that isn't in the code, okay? So it's a cracking piece of ACAS usefulness. Go back to it. The second thing I wanted to say about them is remember, they don't deal with discrimination. And if someone wants to make an allegation of discrimination, then they can refer to the protected conversation. So the circumstances in which they're useful are really, really quite narrow. And they are, there's not nearly as much take up of them as you might imagine. They're not a magic bullet. They can be useful if you're sure you're standing on really good ground on everything else, and you're as sure as you can be that there are no discrimination issues that are likely to be brought. By all means, use them. They can help you. They can help your colleague. But because of the cap on tribunal compensation for unfairness, because solicitor Google will tell you that you can claim unlimited compensation if you make a discrimination claim, so many people try to shoehorn discrimination into their situation. I blew the whistle. You know? You're doing this because I'm old, because I'm young, because I'm black, because I'm white, because I'm a woman, because I'm a man, because I'm gay, because I'm straight, because I'm disabled. We can all fit ourselves into at least one of those categories. And so you need to be standing on really solid ground before you have that conversation. And for heaven's sake, please don't let the managers you are working with do this on their own without your guidance, because that way disaster lies. Good. Okay. So questions, and I can see we've got one coming through already. Tim, I'm not sure how many others we've got coming up. We've got one here. Settlement agreements don't protect employees from ex-employees raising discrimination claims with the ET after they leave the company. Any lawyer can answer any question with the words, it depends. And frankly, it's a habit we have to be really careful of, because it can carry over into our real life, as it were. Darling, doesn't my bum look big in this? It depends. You know, some answers you just don't want to give. A settlement agreement should protect employers from ex-employees raising discrimination claims with ET after they leave the company, in respect of any claims that they might have had in relation to their employment or its termination. And that's if if the settlement agreement is properly worded. It depends if the settlement agreement is properly worded. If it was properly worded, it should be an absolute cutoff. That's it. Sign this, you have no rights against the company. The past is dealt with. What they can't deal with is the future. So the classic one is post-employment discrimination in terms, or victimization, in terms of something like a reference. Well, it's a good idea in a settlement agreement to say, we will only give this reference, dates and terms and of employment dates and job title, you know, something like that. Because otherwise, company rings you up afterwards and says, can we have a reference? And you say no, or worse, somebody says, yeah, you know, God, they were a right troublemaker. That will not be covered by the settlement agreement. And frankly, it won't be covered by the settlement agreement, even if you try and cover off future claims, as some do. There are various legal arguments as to why that doesn't work, and there's always a way around it, in my experience. So that way, settlement agreements do not protect the organisation going forward. If the organisation misbehaves after the individual has left, but a properly worded settlement agreement should close off everything that happens before.
Okay. Any more questions from anyone? I'm trying to think if I've got any questions, Jonathan. I mean, it's been been very thorough, what you've said so far. So I don't think I have any. Is there anything else you can you've not covered? You feel like you just want to mention while you have the chance at all, Jonathan?
I want to make my closing point again, Tim, if that's all right. So if you think you heard it first time, then I can watch the numbers fall off dramatically as on the bottom of the screen. But the point I really want to hammer home is be kind to yourselves and to your colleagues and to your former colleagues. What is the big difference the pandemic has made? Everything is harder, and we may be forgetting that as we start to come back into the office, as the restrictions ease. It's taken its toll. People are frightened, people are tired, people are insecure. In practical terms, that could cost the organisation more money, a bit more cash in terms of oiling the wheels on this. So I did say I was going to say, what should awards look like? Actually, that is a point I mentioned earlier, and that's where I was going to slot in this closing point. So I'd probably better put that in now. As a rough rule of thumb, I think somebody on a 3 months notice period is going to need between 4, 5 months, maybe 6, to go away quietly. That's my very rough rule of thumb. You should always be looking to enhance by a month on a 3 month notice period, and probably a bit more than that to get the deal done. So I'd open with 4 months and expect to go up a couple of weeks here, a couple of weeks there. Complicated ones maybe go up to 6. That's roughly where I get to. Yeah. But you know, every situation differs. Do make sure to consult your lawyer. But that's the kind of sort of flavor thing that I sort of tend to have in my head. As I say, no more than a very rough guide. And in the times of pandemics, I would up that a bit. So you know, if someone's on a 3 month notice period, I always offer the 4, and probably I'd find a way to squeeze another couple of weeks on top of that offer straight away. And I wouldn't mind going up a bit more quickly to get the deal done, to get it quickly and spend a few more weeks cash. Now, sometimes the businesses do not like that. They really don't like that. In my view, that will save them cost and expense in the long run, and it will help current employee relations. If, of course, as a business, you really can't afford it, you can't afford it. But I would urge you to try and afford it. And as I say, if it all goes horribly wrong and it comes to me, I could not be happier. But you won't be. The
longer it takes, the more time and resource it takes internally as well, doesn't it?
Exactly,
as well as external resource. So
all that is more difficult nowadays, no question.
Okay. I think that's a good place to. I mean, I've got your details up here, Jonathan, on the screen. I put up for a while. So obviously, you know, Jonathan's here and knows the subject matter very well. So if you need any sort of advice, and obviously Jonathan's somewhere where you can go. Thank you very much, Jonathan, for your time. I found it fascinating and really interesting. I've been making copious notes for myself. Just a slight advert. We do have another webinar planned before the summer holidays, which is around developing a pay structure, which seems to be very much on people's sort of agendas at the moment. I'm talking to a lot of people about that. So if you haven't registered for that, you can as well. So just contact the usual address. And that just really leaves me to sort of say thank again Jonathan for joining today and for the benefit of your wisdom. And thank you everyone else for your time. I hope you found it useful, and we'll hopefully see you at the next one. So thanks again, and have a good rest of your week. Anyway, so thank you very much. Thank you. Bye bye now then.
Bye bye.